Dear participants, the session will be begin shortly. So please use our background. Our background it will be shared in our can use our background for the visiting lecture today.
Kalau login untuk besok itu sama?
The host will be share about our link. Maybe a moderator has been changed, not me, but
Baik. Yeah.
we will change another moderator. So the link will be shared maybe before 1 hour or 2 hours before to share with you.
Besok, ya, besok pagi ya. Besok sore. Oke. So saya berbicara tentang pagi. Saya berada di Jerman sekarang ya. So di sini jam 9. Saya selalu bingung ya.
Yes. And now 3 o'clock at afternoon today in Indonesia.
Ya, saya masih punya jet lag. Bangun jam 3 di malam, jam 3 di pagi. Karena untuk otak saya masih jam 9 di Jakarta. Tapi ya tentu saja.
Good morning, Prof. Stefan Koos.
Setengah malam ya, setengah pagi ya. Halo, good morning.
Good morning.
Halo, Prof.
Good morning, Prof.
Selamat sore.
Iya, selamat sore in Indonesia. Selamat pagi in Jerman.
Halo, good morning.
Yeah, good morning.
Guten Morgen.
Guten Morgen.
We can start today. Okay.
Yeah.
Maybe our Secretary of Prodi of Notari will be on Zoom. So, and the head of our study program is already in Zoom, so we can start today. All right. Good afternoon, ladies and gentlemen. Welcome visiting lecture with the theme Technique for Making Notary Deeds. I am Siti Khairunnissa. It's my pleasure to be host today for this session. Ladies and gentlemen, before we start, I would like to greet the head of Notary Master Study Program is Professor Hasim Purba SAMHum. Our Secretary of Notary Master Study Program is Prof. Rosnida Sembiring SHMHum. Our presenter, Mr. Stefan Koos, as a guest speaker today, and all the participants in our Zoom, maybe a student from the Notary Master Program. To our students, good afternoon. So before we start, I should read the housekeeping today. Before we begin, I have a few housekeeping notes. If you have any question for the presenters, please use the chat feature in this Zoom. Maybe in this Zoom, please type them into the question box in our Zoom. If you are not asking a question, please keep yourself mute during the live question and answer. First of all, may I briefly introduce to you our guest speaker, Professor Dr. Stefan Koos from the University der Bundeswehrmannschaft. Is it right, Mr. How to spell
Bundeswehr
Bundes.
University Munich.
Bundes University?
Bundeswehr
Okay.
itu adalah namanya German Army.
Okay. Bundes.
Bundeswehr.
Bundes University.
Bahasa Jerman tidak sulit untuk orang Indonesia, sama seperti kalau itu bisa membaca, bisa bilang itu ya. B-U-N-D is Bund ya, but it's not tidak sama seperti Inggris ya. Inggris tidak pernah tahu ya. Jerman tidak sulit.
Thank you, sir.
Grammar aja sulit ya.
Okay. Okay. He graduated from the study of law at the University of Würzburg, Germany, in 1994 till 1995. Judge at the District Court Stratroda, State of Hungaria, Thuringia in civil law, agricultural law, criminal law, guardianship law, and doctoral at University of Constance, Germany, postdoctoral qualification, habilitation at the University of Constance, Germany. His area research is civil law, competition law, consumer protection law, cyber law, and the conflict of law. Since 2016, academic collaboration in Indonesia with the Business Law Department of Business University at Jakarta. 2011, visiting professor. Yes. Visiting lecturer at the Law Faculty of University Islam Riau Pekanbaru. And now 2022, adjunct professor at the Law Faculty University of Erlangga, Surabaya. His recent publication is international with strafrecht, Stodingers Komentar Zoom, Burgerlichen Gesetzbuch, AZBZB, IPR with the Karl-Heinz Faeser, conflict of law in competition law and intellectual property law, digital globalization and law, like Sessentia Law Review for Volume 6, number 1, 2022, and many more. His publication I cannot mention one by one. So here's some summary from the Professor Dr. Stefan Koos. So we can start our your presentation. The screen is yours, sir.
Selamat pagi. Saya dulu harus minta maaf. Saya tidak practitioner, ya. Saya tidak notary. Saya tidak lawyer. Saya akademik aja. Dan saya harus bilang saya tidak pernah kerja banyak dengan notary. Ya, notary. This notarial education is part in Germany integrated, not as you do it in Indonesia. We have always the same education for all law experts. So we study for 2 state examen, and the second state exam is the practical state exam. And then we do all stations. So we go to the lawyer, we go to the judges, we go to the administration, we go to the courts, and so. So everybody who is produced here is practically same, and then we start with that. So I don't know why these stripes come, but we'll have a reason. So I was asked by Professor Rosnidar to deliver that lecture, and I asked myself, what can I do here for giving you a plus value? And so I decided to combine it with one of my main interests, which is the cyber law. And this is how we go on today. I will give you a short introduction about the differences between the civil law and the common law notary, which is important because otherwise you would not understand the issues of the cyber notary, of the electronic notary. It depends on that, definitely. It depends on that. And as usually in Indonesia, we find a lot of papers about topics actually, I would like to get rid of these stripes here, but I have no idea how. Do you see the blue stripe in the middle of the slides? You also see that?
Yes, overview. Yes.
Huh. I have no idea why these stripes are. Oh, yeah, it will be in all slides. I have no idea why. No idea why. Okay. It is important that is many drafts of papers in Indonesia which I read, they just refer on a lot of to Indonesian law, which is a problem because Indonesian law is same like Germany, a continental legal system. And so we may have a problem by just transferring it. That is what I would like to talk about. And then we will talk about the notary in Germany very short, because it's not so important that you know all the details. And then we will go very fast to the notary in Indonesia and talk about, first of all, which is the issue of the cyber notary in Indonesia. Maybe one or two or maybe more of you will know the issue, the problem of the cyber notary in Indonesia. However, maybe not all. So I will give you an overview about the problems which are discussed in the Indonesian scholar discussion. After that, we will talk about the definition and the functions of the cyber notary in the contemporary understanding, and we will then we will talk about the cyber notary in Germany, EU, which is not a task for itself or a purpose for itself to know how it is in EU or in Germany. But I would like to show you the trends of the cyber notary, which we already achieved and which we discuss in a moment. And then in the end, it will be more or less tomorrow. Actually, I have 110 slides. I will not talk about all these 110 slides. Actually, we could also talk about electronic signatures and about the issue of the data protection in this and so, but this I will spare most likely. I will go tomorrow to the cyber notary in Germany, EU, and the electronic signatures, maybe a little bit. And then in the 16th of November, we will talk about the future of the notary in the digitalization. But this topic is a little bit misleading because I will talk more generally on legal tech. And we'll show you about especially how the artificial intelligence may change or may not change the picture of the legal profession, especially of the lawyers and especially of the notary in the future. So I'm so sorry that we have that stripes. If you give me if you allow me, I will try to delete it somehow if it's in my place. I don't know if it's really in my place, but I cannot do anything here. So it seems that someone of the hosts maybe made that. Maybe
participants. So we can you can reply to reshare again.
Yeah, I will do
close.
that. Yeah. Okay, now we have it without that disturbing thing. Sometimes the details disturb, right? So let's start. Why it's so important to, first of all, say something about the difference between the notary in the civil law and the notary in the common law. Because basically the notary in the common law, especially in the United States, has very more few tasks and purposes than the civil law notary, especially the civil law notary in Germany. We see a big difference in the task, which makes it understandable why. In the US, they may have less problems to integrate digitalization technology into the work of the notary, because the common law notary, the public notary, the notary public in the US has more or less the purpose, the task of taking oath and affirmation and certify signatures and copies. This is something we must keep in mind, because the notary public in the US is often not a qualified law expert. And as that is not the case, it is sometimes, or many cases, the notarization of US notaries are not recognized and not accepted in other countries out of the United States, with some exceptions. This is important because, and it is understandable if you see the difference to the notary in the civil law countries. And this is also an issue in Indonesia, as I know it's discussed. And the main opinion is that is rather like we see it here in the example of Germany. You see left the sign of the Bavarian notary. They are qualified lawyers. They negotiate, they help negotiation and drafting the contracts. They give legal advice that is at least also for the Indonesian law disputed, not so clear, but most of the scholars say, yeah, the Indonesian lawyer has the purpose also to give legal advice, settlement of estates, creating of companies and its status, writing of wills, power of attorney, interpretation of the law, mediation. You see why this is important. If we talk about modern digitalization technologies, then we must say if it's about mediation or interpretation of the law, it may not be so easy to integrate something like the artificial intelligence into the notary law. Later, we will also see a big difference to the German law and the continental law when it comes to the question whether the blockchain can change something in the notary work. And I want to maybe send in front of what we will see in the detail later, that the main opinion in Germany is that the notaries are very relaxed in the light of the modern technology and the modern digitalization, even if we see from international conferences the idea that the notary may be abundant in the future. No, that may not be the case. We'll see why later. And this is the notary in Germany, and then you already will understand why it's not so easy. The notary in Germany is an independent holder of a public office for the certification of declarations of intent in the field of precautionary administration of justice. He is self-employed, he's not commercial, because this is important for the independence. We have a regionally different notary model in Germany because we are a federal state. So depending on the state, on the separate state, whether Bavaria or Berlin or North Rhine-Westphalia, we have the Nur-Notar in Bavaria. This is the full-time notary, which does not do anything else than notary task. Very lucrative indeed, but very specialized. And that model is originated from the French model. That is what the French do. And this is historically very easy to understand because Bavaria was highly influenced in the Napoleonic time by France. France, same as a big part of Western Germany, was occupied by the French troops. And so in part of the Germany before the Bürgerliches Gesetzbuch, this is the pendant to the Burgerliche Wetboek of Netherlands, we had the Code Civil, the Code Napoleon in Germany, in part of Germany. And on the other side, we have the lawyer notary, which is a lawyer with also notary function, both in other parts of Germany. The notary must be independent and impartial. He is subject to the duty of confidentiality. This is not surprising. This is the same in Indonesia. The legal basis is the Federal Notary Act, the so-called Bundesnotarordnung. This is the abbreviation, and some professional guidelines by the Chambers of Notary, which is also a state. We have a state. The term notar is legally protected, cannot be abused for other purposes. And we have a very restricted access to the notarial profession, which is depending on the need for an adequate supply of notarial service to the public, to the civil public. Yeah. So because if there are already enough notary in some region, there will not be accepted a new notary. So this is a limitation to the access to the profession by that rule. We have a uniform federal fees system. They cannot, of course, not negotiate the fees for it. So there's a fixed fee system, and we have a certain public liability. If we compare that, this is the German Notary Act in paragraph, or you would say section 24. And important is paragraph 1, the office of the notary, and this is important, also includes the other care of the parties involved in the field of preventive administration of justice, in particular, the preparation of draft documents and the provision of advice to the parties involved. And as I remember, that is in the Notary Act in Indonesia not so expressively ruled. Yeah, so the Notary Act is very open in that. So it's open for interpretation, and some interpret it this is not forbidden. There is nothing written in the act which forbids the advice by the notary, and others say no, this is closed. Yeah, we have only that what is mentioned, and it is a very, very important preliminary question for the question of the cyber notary, because if the notary purpose is in Indonesia very open and is also a task for the notary to give advice to the parties, then it will be very difficult to integrate digital technologies so easy, because then it would be rather like the German notary. However, if not, it would be rather like the notary public of the US, and then it would be maybe easier to digitalize and automatize certain purposes of the notary. So this is Indonesia. You know it already. Originally it was the Reglement op het Notarisamt in Indonesia. I love to read these old laws in Indonesia coming from the Dutch, because I cannot speak Dutch. Many people say dankjewel to me or goedendag, because they think I'm a Dutch, because my language is called Deutsch, yeah, and then the people confuse it with Dutch. Speaks Deutsch, then he will be very angry. I'm not Dutch and they are not Germans, so our language is different, but I love to hear the sound of the Dutch language. That's why I always must read that. Burgerlijke Wetboek or Openbaar Ambtenaar. That is very cool. But actually what is interesting us is law number 30/2004 on Office of Notary Public, amended by the law number 2/2014. And that is the main, what we must have concern. We have a full-time notary, it's actually the main opinion is the notary ensure legal protection for all parties to the deed. That shows that actually the Indonesian notary is more close to the German notary than to the US notary. And legal counseling in connection with doing deeds. The question is the strict passiveness of notary. This is considered too rigid. I gave you some sources for that. This is a new article from Utomo, 2022, issued in the end of the middle part of my lecture. You will find the sources in that presentation, which I, of course, after the lecture will give you as PDF. And of course, also the mediation, that is the same issue. So now, how the question of the cyber notary was evolving was developing. And if you read this big amount of articles, I only must admit that I only read the English articles, the Indonesian articles. I did not translate me because not enough time, but already the English language articles are, I think I read 12 or 13, 14 articles of that. And they all start with how this term of the e-notary or the cyber notary arise. And actually, the first use of something like cyber notary was in the proposal by the French delegation to the so-called TEDIS group in 1989. The development of the ED, the electronic data interchange, was a project of the 80s. Just for ensuring a safe and secure commercial data exchange for trade purposes in the European community then. And in 1989, it was decided that, or it was discussed how to bring more trust, higher trust level into that electronic data interchange. And actually, that was not a question, first of all, aiming to the notary development. It was more a question about making the data interchange, the electronic data interchange, safer by putting in a certain trust factor, which should be a third trusted person in this process of transfer of data. So the integrity and the confidentiality of the ED transactions and the use of digital signatures should be ensured by certain transaction notarization services using for that third-party industry organizations, not the notaries as we know them nowadays, industry organizations, certain industry associations or peak bodies of the industry, which were called in that proposal as electronic notaries. Yeah, so because they had notary functions. So basically you can say it is we approaching the topic in this not from the profession of the notary as we know it, rather from the question of trust, to integrate trust into legal transactions and call this trust function notary function. Yeah, that's the point which you must understand. This is indeed very important for a comprehensive understanding of this, the meaning of the trust in the law. And this is the trust factor which is really has to be outlined here. On the other hand, we have the term of the cyber notary from the United States view by the American Bar Association in 1994. The purpose for that was also not creating a certain notary, but rather how to solve the problem of an international non-acceptance of US notarizations by foreign notaries and foreign jurisdictions. As I mentioned, the US notary has not necessarily an expert position in the law. It's rather a functional purpose. And therefore, especially continental legal systems were not accepting the notarization of US notaries. This means the idea was how to build a bridge between the common law and the Roman law notary by developing specialized notaries with special legal expertise. And that was focusing first to the question of the expertise in the law. They should have a higher expertise in the law, so different to traditional notary public, who's actually widely not acknowledged. They should be accepted by a high level of qualification in law and important in information security technology. And that would lead to a certification authority as a trusted third person. We will abbreviate that as T3P. They should be in one side and on both sides, computer specialist and legal specialist, able to electronically certify and authenticate all elements of an electronic commercial transaction, but by the legal expertise in that way that it is accepted by other jurisdictions. And the concept of the cyber notary then is here described in that slide. A concept that adapts the use of computers, cyber or online by notaries in carrying out their duties and authorities based on trust when transaction between parties over the internet, the security of transmission, the integrity of the content of the communication, and the confidence that such transactions will receive legal recognition so that binding contract is enforceable and enforceable in the international area if it's cross-border, especially in cross-border cases. And the requirements for that would be expertise in the field of law and computers, authenticate documents electronically, verify the legal capacity and financial responsibilities. This needs maybe the requirement of an attorney. So the question is whether that notary has to be an attorney and verify financial responsibility and legal capacity of the parties. And compared to that, the electronic notarization, the TEDIS, is here we have an independent third party. That was this organization of the trades, of the companies that records transactions between one party and another on an electronic basis for international trade traffic. A notarization process, authentication of a signature on an electronic document through a certain method, which leads to output in the form of a notarial deed produced or processed electronically. So the difference to the cyber notary is here is no requirement to confirm the content of the document. It is only aiming to authentication of the signature. So this is actually the beginning of the cyber notary. So if we talk of cyber notary, which is the term, if you Google cyber notary, you find mostly papers from Indonesia, English language papers from Indonesia. You would find electronic notary, or you will find maybe digitalization in notary. And in Germany, I must say, we don't discuss that issue as you discuss it in Indonesia. I have the impression you discuss it in Indonesia as coming from the model view of what is a notary, and maybe make a categorization of a digital notary, of a cyber notary. However, for us, this is not actually a comprehensive topic. It is rather a topic in the whole notary law, how we integrate digitalization technologies for the conventional notary. So it's rather from the task of the notary coming, whereas you come more from the profession model or the profession pattern of the notary. And the cyber notary is actually coming from the US originally, but it is used rather in the sense how we use it here as electronic notarization or electronic notary or e-notary. So the advantages are clear. It is adequate to the era of globalization. We had a rather, I suppose we had a big shift with the pandemic because it leads the people to say, oh, I don't want to go to notary. I want to do certain things online or so. So it maybe boosted the development to digitalization. But this is not also special for the notary. This boost took place in all of the digitalization. Otherwise, we would not use this Zoom here. Before the pandemic, I did not even know there is software like Zoom. I never used that in my life before, yeah, and I never would make YouTube movies about law or so. This is all boosted by the pandemic. So the pandemic had also a good side, not only a bad side. More data security, of course. This is also not so old, yeah, because with the internet we have, of course, the interest to make it safer. Less or no evidential issues in the court proceedings. How we handle the question that digital documents are changeable, are not really fixed, yeah. So how we can make it safe, and the validation of the legality and identity by one authority. And the definition and the aspects you find in the literature, I have that from the Indonesian literature. I just want to present you some. Notary who carries out his duties or authority based on information technology, which is related to the duties and functions of a notary, especially in making deeds. You see here the source. And the other definition is the use of information technologies such as computers, computer networks, and or other electronic media such as teleconferencing or video conferencing in carrying out the duties of the authority of the notary. And the goal is flexibility and facilitating of performing the duties and authorities of notaries in making authentic regarding all acts or agreements or provisions required by the act or with the content wished by the parties. So we see here supporting function of the notary as a trusted third person in information security technology is one of the main aspects. A trusted third person, the notary, and that leads also to chances for notaries because more than the traditional purpose of notaries, we can think about that notaries have maybe more purposes everywhere where we need in digitalization a trusted third person. Then we have electronic acts performed by classic notaries. We need elements of the civil and procedural law to perform legal acts in electronic transactions. So I should say that we should be careful with the word of disruption in the law because this is also all the time used. Yeah, actually, many of the questions we can solve already with the traditional elements of the civil and procedural law just by amending certain aspects. Yeah, so I'm one of the people who say that the internet, for example, did not really disrupt the civil law. It is still working, and what may disrupt the civil law is the AI, but many elements can still be used. And the question is, and that is what I mentioned, is the cyber notary a function or a specialization of the notarial profession? Cyber notary is a concept that utilizes technological advances for notaries to make authentic deeds in cyberspace and carry out their daily duties, for example, signing of deeds electronically and general meeting of shareholders by teleconference. Yeah, this is maybe the most feasible definition, which already shows we have certain aspects where we have more digitalization maybe and less digitalization, and especially we talk about the shareholder general meetings. So here we come to the functions of a cyber notary, of e-notary. The notary is a trusted third person to form a bridge in the cooperation for contracts, agreements in the form of electronic transactions. This is the first purpose. Second, we have the implementation of a notary authority based on information technology. So we have to discuss about notarization services, notaries, deeds digitalization. And third, we have a supporting function of the notary as trusted third person in other aspects. For example, in information security technology, very interesting indeed. For example, source code escrow. Source code escrow means if you are a software company and you deliver a certain program to a company which use this program, for example, for the human resource or for their IT, then the risk is always there that the delivery company, the software company, which developed that software, maybe falls out, maybe go bankrupt or is not able to deliver anymore, and especially to maintain the software. And for that, a company which is acquiring that software has actually the interest to have also the source code of the software. Because then the IT expert of that company can themselves adapt the software and maintain the software without the help of the selling software company. However, of course, this source code is part of the copyright of the software company. So the software company is not interested to give out that software code. And to solve that problem, one of the solutions is the source code escrow, that we have a third trusted person which has this source code, and in case of an emergency, when the delivery company is not able to adapt or to adjust the software in the customer company, then this third person would give the source code out or would help to adapt that. This is one of the purposes which in the future maybe could be also a task of notary. Or notary can be a registration authorities, legalization of verification of conventional identification before the issuing of an e-certificate. So the notary will check out all the paper forms and prepare the digitalization of this identification in the authority or whatever. And another important aspect or interesting aspect, which is not discussed yet, is wherever we have trusted third person needs. For example, in PBC, performance-based supply chain management, very interesting, because in performance-based supply chain management, we have the question that a company is developing something and delivering something to another company in the supply chain and is paid by the success the customer company has with the implementation of the product, the raw product from the first part of the supply chain. However, this needs sharing of company secrets, because otherwise it cannot be assessed whether there is a process of exit of success or not, and what is the success. This could be also a future task of notaries as a third person in this technology. So we have here important aspects of this notary. First of all, validating the legal contents of the document, validating the digital signature, validating the identity of the signer. Switch off the micro, please, whoever that is. Thank you. Validating the capacity of the signer, validating the authority of the signer, and including the validation of the digital certificate. Further aspects are the electronic notarial deed. So in which amount we can use digital documents and digitalized documents and make these documents able to be serving as a bukti, as a proof in the civil procedural law. Notarial online procedures, so notarization of online company formation would be an example for that. Especially by telecommunication instruments like Zoom or other transfer of pictures and sound, and secure digital archiving of documents. And I will show you that in that, Germany is not very far in the digitalization, but in this aspect, we are already quite far, and we have implemented all this already in our law. And tomorrow, I will show you how we implemented that. Let's come to the Indonesian law and the problems of the interpretation. of Indonesian law, and we start here with the Indonesian law number 2, 2014, the revision of the law number 30, 2004, and here the elucidation of Article 15, which is the most important point. So I'm sorry, I will read it in Bahasa, but there will be a mistake. So I have it, of course, read in English. I know what is written here, but for you I will write it. Yang dimaksud dengan kewenangan yang lain yang diatur dalam peraturan perundang-undangan antara lain kewenangan mensertifikasi transaksi yang dilakukan elektronik, and then in parenthesis cyber notary membuat akta ikrar wakaf dan hipotek pesawat terbang. So this is actually the only expressive mentioning of the cyber notary. And I have no idea. I have no idea about the process of legislation here. I don't know whether the legislator was really thinking about what he does by just inserting these two words, cyber notary, secara elektronik. Can be that that this was some referee of the ministry, very modern thinking, and was caring with that, and just said let's make them well modern and insert that. Can be that the legislator thought, okay, we let it open for further development and just already open it, and then it was not fast enough amended. I have no idea, but we must discuss it. And here is this elucidation, and also in English, electronic cyber notary, and we must read it with that Article 15 of the law number 30, 2004. In addition to the authorities referred to in paragraph 1 and paragraph 2, notaries have other authorities as stipulated in laws and regulation. Together with that elucidation, it means that the notary has also the purpose and the authority to certify electronic transactions as a cyber notary. Means we have already the cyber notary in Indonesia. The question is not, therefore, whether we have a cyber notary in Indonesia. The question is, what can the cyber notary do? And the question is, after all, how much legal safety, legal security we have with that inserting of the cyber notary term in the Indonesian law. And I will not surprise you, who already knows about that issue, that the legal certainty is not very high. So the problems is, first, we have no clear definition of the term cyber notary in the law. This is up to the discussion, and indeed there is amount of articles, an amount of articles about that since 2016, more or less. I think the first 2 years it was still not so active, but since 2016 and then 2019, in the last 3 years, there was written 1 million of articles all about that. Some articles better, some articles worse, some articles more or less copying from other articles, but there was also very innovative, and the best of the articles I inserted in my list of sources for you. And second, we have no regulations regarding the authority of notaries in cyber notary activities. Third, we have a conflict with other principles of the notary law. This is not consistent. Fourth, we have a need to harmonize the notary law with the civil law. And fifth, we have no legal certainty for the notarial praxis. So what would be optimized in cyber notary if we come to that? First, optimizing a cyber notary would be that the notarial deed can be made in video conferencing. Yeah. Second, a deed written on paper can be the possible one, or the electronic deed, or an electronic document, which is with a less proof function than the electronic deed. Then we have a identity verification, full electronically, download proofs, ID from authorized trusted entities, without having to send KTP or passports or bring it to the notary. Then fourth, we have the option of download documents from trusted document storing resources, for not only for the lawyers and for the notary, also for the courts and the authorities, which should spare a lot of work, because in that sense we can avoid the doubling of storing. So we would have a central storing place where all these documents are safe, maybe saved by blockchain technologies, and so, and can be trusted, downloaded by all interested and authorized parts, including, of course, the the notaries. And last, the digital signatures and the digital fingerprints. This is already more or less implemented in the law. And one of the conflicts is already Article 1, number 7 of the law number 2000 from now 2004, I think, or is it 14? I forgot. One of the two, which says that notarial deed hereinafter referred to as deed is an authentic deed made by or before a notary according to the form and procedure stipulated in this law. Means actually the clients must come to the notary and do it there, because it can be doubted that that means before a notary, before means in the Zoom. Actually, this is not changed with the law number 2014. So this means it should be in the place of the lawyer, of the notary, and cannot just be done by teleconferencing. And that would also set a big limit to the digitalization of the notarial deeds and of the notarial authorities. And RTO, that was for 2004 indeed. And this is Article 16, paragraph 1, lead C of the law number 2014, attaching letters and documents as well as the fingerprints of the depositor to the deed minute for protocols. Yeah, and that is also showing that we have still no digitalization, but more analog technology, attaching letters and documents and fingerprints. There is not written something about the digital fingerprints or digital documents. So this is obviously contradictory to the term of the cyber notary, which should be one of the authorities. So it can be questioned in which areas of the Indonesian law the cyber notary plays any role. And here we have the evidence issue, which is also problematic in law number 11, 2008, concerning electronic information and transaction EET, which says in Article 5 that electronic information and or electronic documents and or the printouts thereof are valid legal evidence. Very nice. Sounds good on the first side. But on the Article 4, in the paragraph 4, it's written that provisions on electronic information and or electronic documents as intended by paragraph 1 shall not apply to, and then B, certificates together with their papers that under laws must be made in notary deed or deed made by land conveyance. Means the deed made by the notary in electronic form is obviously not a legal evidence in the sense of Article 5, paragraph 1. And that is contradictory, of course, to the concept of the cyber notary. Now, the question is how to solve this. I have here one source from a very good article from Mutiara Astari Rafli and from Humaira Latumeten, both from 2022, about Article 5, paragraph 4, which shows that the document by the notary electronic cannot have valid legal evidence under recent Indonesian law. We have here the interpretation that such electronic documents would not be authentic deeds, but mere ratification of deeds under the hand. That should be the consequence of what we saw in the slide before. This is the one opinion of Humaira Latumeten in that source. You also find in the end full cited. However, the different opinion of Mutiara Astari Rafli from 2022 says that the meaning of the provisions of the article must be done flexibly so that a more flexible meaning is obtained. This is actually a little bit, how can I say, tautological, yeah? However, it says, and this is a good idea, it says that we should interpret it maybe in a sort of a open analogy or openness, because maybe the legislator did not foresee the development to the cyber notary in a more flexible way. And that is indeed a technique for interpreting law. Article 5, paragraph 4 should be interpreted that the deed made by a notary in the form of an electronic document and or its printout is at least legal evidence if it is not a notarial form obligatory. So it can be chosen whether you have a notary form or not. If it's not obligatory, then then it should be one, not be a problem. This is the idea of Muttiarato Astari roughly. And if we see law number 40, 2007 concerning limited liability company, electronic deed of minutes, then we see that Article 77 says, other than the convention of GMS as referred to in Article 76, the GMS may also be convened by ways of teleconference, video conference, or other means of electronic, which enables all of the GMS participants to see, hear, and participate directly in the meeting. It shows that we can use telecommunication instruments like Zoom for these meetings. And that, gives the idea that we can also let the notary participate with telecommunication means like Zoom in these meetings. However, there are voices there are scholars in Indonesia who say this is even dangerous for the notary, because if the notary is online and not there, and some part of the GMS is there and the other part is online, so they make it hybrid, then the notary has not the situation that he saw them all in the same way. And that is for the notary not possible. So the notary must in any case be fully online or fully offline. So this is maybe a problem. And the interpretation of Article 77 of the UUPT is by Muttiarato Astari roughly, that by opening the option for general meetings of shareholders by ways of video conferences, the Indonesian legislator opened necessarily the possibility of a digital deed of minutes. Because it is digitalized, and then it doesn't make sense that the notary cannot make all digital if he can be in a distance in the Zoom meeting, in this meeting of the shareholders. However, the deed of minutes is not in any case obligatory. That would also support this opinion, because the opinion is we can have a proof quality of the digital deed if the notary form is not obligatory, but to the free decision, and that is in this case. And Reza Amrullah on the other side from 2019 put the opinion that authentication of electronic documents in the form of the minutes of the general meeting of shareholders in the concept of cyber notary can be done by means of a notary, does not need to be present during the general meeting of shareholders of the cyber notary takes place. Sorry, this is just the pure citation. So sometimes the sentences, but I think the meaning comes over. If the notary is present directly at the meeting, then it's actually dangerous. That is what I mentioned for the notary, because in the cyber notary, there are meeting participants who attend using teleconference or video conference that do not allow the notary to get to know all meeting participants who were present at the meeting. Making deed of minutes of the meeting is sufficient to be made by a notary based on the minutes of meeting under the hand of the authorized shareholders to the board of directors to be drawn up by a notary. So not clear, yeah? Some say so, some say so. The law seems to open the option. However, the scholars are not sure whether that is really opening, or whether we must have clarifications of the law, whether that is possible or whether that is not possible. And this is the idea of Khairunnissa and Saleh from 2020. The mentioning of cyber notary in the law 2014 is not a sufficient legal basis for making a deed with a virtual meeting for its signing. And taking into account how important it is to have a legal certainty about the result of the notarial activity, actually it cannot be trusted. And actually it is very risky to just rely on that one scholar says okay, the other scholar says not okay. So however, altogether, we seem not to have a correct legal basis for a real cyber notary in the ideal form, which we mentioned before. Here are the sources I mentioned. You find all the sources, and all the sources are open source. You can access it very easy. This is the exception. Reza Amrullah. This source is not accessible. I don't know why, but if I click the PDF, I only get the summary, and the PDF is just not coming. So obviously that journal is already not existing anymore. Maybe Authentica, I have no idea. The second issue or the second year, I have no idea. But in the summary, you already see his opinion. Okay, I think we have €1.20. I think I will go on, then we have a little bit more time later tomorrow, and we are not so much in a hurry. We come now to the cyber notary situation in Germany and EU, and maybe you allow me some words about legal comparison, because legal comparison is something I always mention in every of my lecture in Indonesia. I do that because I all the time read legal comparison here. Yeah, so I all the time read articles about this in that country and that country. Yeah, because that guy was traveling to that country and then he said make something out of that, and then just compare something. Or get often the application of doctorate candidates who want to write a doctoral thesis in my chair. And yeah, they made some holiday in South Africa or in another kind of Thailand or nice country, and then they want to compare something totally irrelevant for me as a legal expert in Germany, so or a practitioner in Germany. What I want to say is legal comparison is not a self-purpose. Yeah, a legal comparison must have a background. You must know what kind of information you can usefully take out of the legal comparison for the area and the part of the law you want to analyze. So in this case, it is important. In the other case, is best. In the best case, interesting and nice to know. Yeah, you can be an expert on foreign law, and then you can do that. Yeah, but if you want to make legal comparison, or you want to be a lecturer, a guest lecturer abroad, and I'm a guest lecturer in Indonesia, I already a long time ago gave up these lectures about this in Germany and that in Germany without asking why S1 student must know about that. Yeah, so it is. I only do that if it's necessary. And here it is indeed interesting because cyber notary audit was Siri. The cyber notary situation in Germany and the European Union is maybe a contoh, yeah, a good example for the development. We also not that far, but maybe you know that the European Union in the part of the digitalization is in the moment very active. So we get a legislation on artificial intelligence and also the liability aspects of artificial intelligence. We got next year, we get a digital market acts about the antitrust issues of multilateral digital markets. We will get a digital services act. We will have a lot of additional aspects of the data protection after the data protection regulation. So we have commercialization of private data, who is the owner of the data, and even we regulated in European Union already the payment with data, the payment function of data in platform economy. So we have a strong position in the digitalization, and in that we are quite far. And here we have the first interesting article, the section 20, paragraph 1 of the Bundesnotarordnung, the Notari Act on Notarial Services, the electronic notarial deed. Notaries are competent to perform notarizations of any kind and to certify signatures, qualified electronic signatures, hand signs, and copy. And section 39A talks about the certificates. The certification and other certificates within the meaning of section 39 may be issued electronically. Certification of qualified electronic signature shall be issued electronically. Document created for the purpose must be provided with a qualified electronic signature. The certificate must be accompanied by a confirmation of notarial status by the competent authority, and so on. So we have here the electronic notarial deed, already a start of it. And these are just an overview about the certificates, simple certifications, certificates when certifying a handwritten signature on a hand sign, or the drawing of a name signature when establishing the time at which a private document was presented, when certifying entries in public registers, copies, imprints, photocopies, and the like. And in the case of other simple certificates, a document which must contain the certificate, the signature, and the embossed or color printed seal of the notary, and which shall state the place and the date of issue shall suffice instead of a record. So this is the simple certificate, and the electronic signature is the section 33. The notary must have a permanently verifiable qualified certificate from a qualified trust service provider and the technical means to create and validate qualified electronic signatures. And the qualified certificate must be provided with an attribute which identifies the holder as a notary and also contains the notary's official place of business as well as the country and the chamber of notaries in whose district the notary has its office place of business. So we see the handwritten signature, and this is something also you will know already because this is actually state of the art, is a qualified electronic signature, and the notarial seal is replaced by the notarial attribute in the sense of this section 39A paragraph 2 of the not the Notarial Act of the Document Act. So when creating electronic notarial deeds, the signature must be generated personally by the notary, otherwise the deed is invalid. And in principle, any endorsement certificate that was previously generated in paper-based form can also be represented in electronic form. Then, very interesting maybe for you is that electronic documents are achieved, the EDA, by the Federal Chamber of Notaries. This is very, very new. And it started to be active in the 1st of July 2022 and was in vigor since the 1st of 2022. The ordinance on the maintenance of notarial records of directories, which is German, die Verordnung über die Führung notarieller Akten und Verzeichnisse, die Notakt 5. So this is the regulation here, the ordinance. And it gives the duty to the notary to produce an electronic copy of notary documents. All new notary documents must be in the form of that electronic copy, which will be necessarily archived in a central notary electronic documents archive of the Federal Chamber of Notaries. This means we have this electronic copy, which is archived in the central notary electronic documents. Remember, archived. Remember that was one of the ideals of the cyber notary, that we have a central place where all the documents are one time and safe, stored for accessed by other notaries and maybe also by courts and authorities. The scan of the this is the scan of the in paper form, the by notaries original as PDF. And each newly established deed is scanned and transferred to this EDA in the future from now on. So this is what happens. We have here still the traditional storing of the paper form, so not totally digital. And on the other side, we have this electronic document archived in this one. The paper form is regularly only for 30 years. After 30 years, it can be deleted or can be destroyed, but the digital form will stay there archived for 100 years. So after 30 years, you have still this electronic archive. And in the beginning, in the first time, we still have this paper form, which is a sort of a safety, yeah? So a double safety for the existence of this document. So what is the advantage of that? No, very clear. No need to access paper documents in the future. Copies and transcripts can be made directly from the electronic version of the original. So it's just a print of the scan then. The notarial certification or electronic in paper form can be notary copy only in the paper form. The notary has to keep that for 30 years. After that, he can destroy it. So this means this spares place. We have the once only principle. Storing of notarial documents are only in this notary archive. Registers and authorities will later be able to access these via safe links. This is not yet implemented, but will be implemented. So this is a central archive and saves resources for archiving in notaries and courts. It's only stored in one place, and the notary deeds can be used electronically without media discontinuity. So there is no change of media. Of course, this is maintained. And so there should be a certain safety for that. This is the section 12 of the commercial code, which is an example for the electronic commercial register registrations. And later we will come to that also. Applications for registration in the commercial register So, for example, founding of a commercial company or a firm shall be submitted electronically in official certified form. The same form shall be required for a power of attorney for purpose of making application. Certification of a notary pursuant to Section 22, subsection 3 of the Federal Regulations for Notary may be submitted instead of a power of attorney. Legal successor for party shall, and so on. Documents shall be submitted electronically. If an original document or plain copy is to submit it, or if the written form is prescribed for the document, transmission of an electronic record shall suffice. So you see already preparation for the digital registering in the commercial register. It is necessary to have it mostly electronically to make the application. So the application for the registration in the commercial register, which is in paper form, is signed by the applicant by own hand. This is the process. In addition, the notary issues the usually certificate, the signature certification in paper form, which is attached to the commercial register application. And this paper deed is transferred then to an electronic form by producing electronic certified copies. So I think it's 51 minutes. I think we left something for tomorrow. There was a lot of input, I think. Do you think I should make the hour full? Or you think we should make we should go on tomorrow with the topics? What is the opinion of the moderator?
Maybe we will be continue tomorrow. So we have a question answer this section. Should be, as we know that we have
no problem. I have the I have full time. It's a 1.5 hour, right? I'm to your for your.
Maybe we will continue. Maybe we will continue on tomorrow. So we have 3 questions from our participant. Before that, I will be thank you for your interesting topic today. It is make increase my knowledge, yeah, because as we know that some points that I would be highlighted. We know that as a lecturer, we have to legal comparison. As we know that you are the guest lecturer, you have a legal comparison is very important between the AU and German and Indonesia. As we know, notary, cyber notary in AU and German is a very different. That's how much the security. As we know, the cyber notary is a concept, technology, utilize technology advance for notary to make authentic deeds in the cyberspace and carry out the daily duties, for example, signing of deeds, electronical, and general meeting of shareholders by teleconference. But in Indonesia has not been implemented. It's not it has not been implemented, as we know that still manual, not by online. But we have to being online, and I have one interpretation that should additional, as we know is number. So okay, the clear as we know that the problem, the number of the problem is the no clear definition of term cyber notary in the law. So cyber notary to make certification, wakaf, hypothec is a limitation. As we think, as I thought, is it the limitation? So for the further aspect, electronic notarial did so be increase and as we know that in the era globalization. So here's 3 questions from our participants. First, from very roughly Magister Notary University of North Sumatra. How about the limitations, period, responsibility of notary in German? Is there a limitations period in the notary in German? Does it have a lex specialist about it in German? Thank you. Here's this question, sir.
Yeah, it is not a special law. It is just in the civil law that this is the regular 2019, the German Federal High Court decided that for the Amtshaftung, this is the official liability of the notary, it's the normal limited period of 3 years. This is the regular limitation period, which we have in the civil code, which is valid. And that decision was made 2019. So it was, but as you know, I am not a long-term practitioner of this notary law.
Yes.
I must admit, I'm not an expert on that, but this is so far I know that the Amtshaftung is just normal. We have this regulation of the Amtshaftung not in the notary, but in the civil code. We have it in, maybe for your interest, in 839 of the German Civil Code, which is generally the liability of officials of authorities, and this also applies to the notary function.
Okay, thank you, sir. So the limited period is 3 years, as we know that from the civil law, and special in civil law in German. Daftung is right. Daftung, how to spell that? Daftung.
Sorry, what?
For the law from the German, Daftung. You say that the Daftung or the law for German?
You mean Haftung? Haftung.
Haftung. Okay, Haftung.
Yeah, Haftung is liability.
A liability, okay.
Yeah,
in German,
but there is English version. You find English version of the civil code. If you go, wait, I will share with you. Then you can find that. Wait, I will share. You go to put into the Google BGB, and then text txt. Wait, I share, and then we can read that together. Actually, that is the good thing. We have the time for that. Okay. And then we have here the first one, and here we have the English version.
Wow.
And we have here the 839.
Okay. Liability, okay.
Of, this one, 8, yeah. Liability of breach of official duty in case of breach of official duty. Yeah, in an official intentionally or negligently breaches the official duty incumbent upon him in relation to a third party, then he must compensate the third party for damage arising from this. If the official is only responsible because of negligence, then he may only be held liable if the injured person compensation in other way. And interesting is this, because it is in the, I think in the Constitution, in the Grundgesetz, added by the duty in certain case that the state must recompensate again the official to keep him free from the liability, because we have a certain principle of alimentation, but this is not so important for this. And the limited period is regulated in the general part of the BGB, and we have here the special time when it starts, circulation, attention, limitation, and then we have the here
3 years.
We have the 3 years, as the regular time for the
section 196. Section 196.
No, this is
195.
For plot of land. Where it is? Wait.
195, sir.
It's 195 exactly. The standard limitation period is 3 years, and that applies to that.
Okay, thank you for the information that to answer the question is number 1. So we move to answer the number 3 and number 2. One of the obstacles in international civil and commercial law practice is the document originating from abroad to be used domestically, or otherwise domestic document will be used abroad to be used as authentic evidence. The
Yeah.
legal issue, Germany can be applied into a notary deed while maintaining its authentic as an authentic deed with the perfect proof quality. Is there a government agency or institutions issue the legal issue?
Yeah, difficult for me to answer that, because this is not really what I prepared here. This is not
Okay.
about actually the cyber notary, but basically I don't know how Indonesia is practicing this. Yeah, so actually the German or the foreign documents will be legalized by the German embassy if it goes to Germany. If I did that for my own marriage also, yeah, so I needed that. And I don't know about these apostille things, how is the practice in Indonesia? Maybe you know it better.
Maybe apostille is legal or legal. Apostille.
Is Indonesia part of that treaty about this apostille?
No, legal is pengesahan in Indonesia. Legal.
Okay, but you are not a member state of this Hague Treaty on legalization. This
legalization.
Exactly. I cannot really give a qualified answer to that. That is a little bit difficult for me to say about that. This is very practical.
Okay. Maybe on the second day you cannot answer for the question. We can keep your questions.
Yeah. Yes, maybe I find it out to this afternoon. I will read about that. Maybe you see. We can discuss that tomorrow again.
Okay. And the last.
Yeah. Is there a legal defect in a deed issued by e-notary, and how the cyber notary solve it? Actually, this is a question for the future, right? For the development of it, because in the moment we don't have actually this, and this is a general problem. This is why the question is very good for all legal work, which is digitalized. Legal issue. Because what I did in several seminars and conferences in Indonesia and Malaysia was talking about the replacement of the law by technology. And we have in this issue, in this topic, I discuss how the human factor is replaced by digitalization. And in the end, mostly I close my presentation by telling the students or the participants, if you are future lawyers, then be ready to be programmers. As we already see in this concept of the American Chamber of Notaries, that the question is the notary must be the gap between the law and the information science and the IT. Actually, the question is indeed, and this is not only to the law, to the notary, it's to all law tasks, how we handle the liability of wrong publication, of wrong production, of wrong programming, especially if it comes to more and more automatization. For example, if we come to the smart contracting issues, smart contracts are self-executed. What if the legal tech is programming that, and who is liable later if the programming is wrong? And basically, the question is not so difficult to answer. If there's legal defect in the deed issued by the e-notary is not different responsible than if it's just a paper document. Basically, we have no disruption here. Whether if there is the option of an e-document, and we must define what you mean with the e-document. If you mean with the e-document something very futuristic like a smart contracting document which is self-executing, this is the future. Maybe, but if we talk about e-document by having some PDF, which is combined with a signature and is then approvable and cannot be changed anymore because maybe also registered in a blockchain, then we don't talk about something which is disruptive. So we don't talk about something categorical different than a paper document. And of course, if this e-document is put in a wrong way with mistakes which are negligent, then for the Germany 839 of the BGB applies, same like to the paper document which is issued in a wrong way, and it comes to the liability. So this is no disruption, but in the cyber notary, in my opinion. However, the more automatized the tasks of the notary could be in the future, the more it is possible that we have to ask, where is the negligence? Is it in the programming or is it in the executing? So there may be a shift of the defects of the negligence to other parts of the process. For example, for the lawyers who make a contract, of course, if the contract is made in the wrong way by the lawyer and the lawyer did not care for certain important aspects and the contract is written, then we see the problem in the disputes in the execution. But in the future, if we have full automatized documents and full automatized contracts, which are not putting the question of dispute in the execution because the execution is fully automated, then the question will be in the liability of the programming. And then the question is, if the notary or the lawyer or the attorney use an IT person to program that, how the responsibility is shared between them and where is really the responsibility if in this digitalization. This is a general problem of the digitalization, but so far in the moment, we don't have this disruptive aspect here, because this is just, as you see in the German law, this is in the moment just a PDF combined with an electronic signature. And of course, when you make this PDF in half offline way, or even if you make the PDF exclusively in a digital way, someone must write it, and this writing work is subject to liability.
Okay.
That's it. Yeah.
Thank you, sir. As we know that we have today we have the theory how to the legal comparison between EU, German, and Indonesia. As we know that legal issue has been discussed for tomorrow. Is it right? The implementation is to be discussed.
What do you mean exactly? The legal implementation?
So sorry, the implementation, not legal implementation, the implementation cyber notary in every country. So
no, we will only talk about that tomorrow. We will finish the cyber notary in Germany and EU,
okay.
And then if we have a little bit time about the e-signature as an excursus, and the question of proof and the question of data protection in e-signature, just an excursus, and then we will talk very shortly about certain digitalization technologies like the blockchain and how the blockchain will influence the profession of the notary. And then 16th, we will talk exclusively about legal tech and especially about the issues of the artificial intelligence in legal tech, which is also applying to the notary. But I will not compare with all European countries or all countries in the world. I will just give you an example in Germany and the EU about that. But maybe we will have tomorrow a little bit more time. So I will talk about the purpose of proof, the proof issue, and the data protection issue of the electronic signatures.
Okay, thank you, sir. Maybe there's more tomorrow. It will be more interesting, as we know that the proof and data protections in the cyber notary.
I don't know. Maybe there is not enough time, but you see, we have a lot of evidential issues here about that, and I think we have the time for that. And then here we will talk about the new technology and the notary. So this is the future of the electronic notary. Okay, electronic notary.
Okay, thank you, sir. So we have
but actually we can that will be easy. Then tomorrow we make a short repetition and then go to the next part.
Okay. Some part has been told in Mr. Professor Koos. So before we end this session, we should take a photo. To take a group photo, maybe, sir? To take a screenshot for the photo. So to all the participants, please use Please open the camera and use your background maybe for the taking photo. Please ready for taking photo. Right. So I should to allow to ready for taking photo for today. Okay. 1, 2, 3. The next slide. 1, 2, 3. The next slide. 1, 2, 3. The next slide. 1, 2, 3. Okay, done. Thank you, Stefan Koos, for Professor Stefan Koos for the interesting topic. Before we end, don't forget to join tomorrow at the 3 p.m. in Indonesia and in the morning and the 9 a.m. Is it right, Prof?
Yeah, 9.
At the 9 in your
Thank you.
at the German. Thank you,
Thank
Prof.
you. Terima kasih atas perhatian Anda ya.
Yes.
Very disciplined, yeah, and not talking and so. And I hope I can do that in the future offline, and not in Zoom anymore. I hate Zoom.
Okay, thank you. It all looks like we have a coverable all the base. Is there anything else you want me to mention before wrapping up?
No.
Okay.
See you tomorrow.
Okay, see you tomorrow. Ladies and gentlemen, on behalf of Law Faculty and the Notary study program, we would like to say thank you who made a visiting lecture today, and thanks for your active participation today. Then have a great rest of your day. See you on Friday. I am Siti Khairunnissa signing off. Wassalamualaikum warahmatullahi wabarakatuh. Good afternoon.
Good afternoon.
See you on tomorrow. Thank you, Prof. See you, Prof.
See you, Prof. Izin live ya.
Oke, Prof. Sama.